Recently, we have seen that NCRB has released its data, and in that data, we have seen that the crime against SC/ST population has been increased, and Rajasthan and Madhya Pradesh stood first in recording the crimes. Hello everyone, welcome to the new series of Drishti IAS. I am Ritu, and today's lecture is about 3 criminal bills passed in the Lok Sabha. So we'll discuss the nitty-gritties of these bills and how they are different from the earlier version of the bills. So moving to the points of discussion part. First of all, we are going to discuss the news, and then we are going to discuss that what are the 3 bills and what changes it has accorded and what are the concern and issues related to these bills, practice question for prelims and mains. So moving to the news part. So on 18th of December, we have seen that Amit Shah, who is a Home Minister of India, had tabled 3 bills, and that 3 bills was the recommendation and earlier version of the bills which was introduced in August, and there were few recommendation which has given to that bill, and the Home Minister is saying that we have changes so many bills that serves the justice to the people. It is not just mere the mouth service, it will serve justice to the people of India, and the earlier version of the bills are outdated in nature. They are colonial period time bill. So they wanted to change bill in order to bring justice and efficient justice system of this country, and throughout the time we have seen that so many things have been changed, the different nature of the crimes has been changed. So whatever the existing laws we have, that was not serving the demand of today's existing justice system. So for that they had introduced 3 new bills. So that's why we are going to discuss this topic. So what are the earlier existing bills we had? So we had this Indian Penal Code 1860, Code of Criminal Procedure 1973 and Indian Evidence Act 1872. But what we have seen that here the date is 1860 and 1872, which is of 19th century bill, and today is the 21st century. So there are different kind of crime, there are different kind of punishment and different kind of stakeholders who have involved in a different kind of crime. So for that we need a different kind of bills which serves the today's demands. So moving to the bills part. So the first bill is that what are the 3 bills and what is the new naming of these bills. So the IPC will replaced by the Bharatiya Nyaya Second Sanhita Bill 2023. The CRPC of 1973 will be replaced by Bharatiya Nagrik Suraksha Second Sanhita 2023. Whereas the Indian Evidence Act of 1872 will be replaced by Bharatiya Sakshya Second Bill 2023. So maybe in prelims question they can ask you that which bill has replaced which thing. So you should know the answers. So these things is very important. Moving to the next slide, which is Bharatiya Nyaya Second Sanhita Bill 2023. So what is the first provision? It has made changes. So UAPA definition of terrorist act adopted. So earlier in version whatever it has been tabled on August, and that time they have given a simple definition of the terrorism and terrorist attack, but right now they have given the similar definition which has been defined as a UAPA act. So the definition is very similar in nature. On the other hand, this has created lots of controversy because so many political leaders, especially the opposition leader, has said that the UAPA is a draconian law and it is harming the security, integrity and sovereignty of India. So that has created another kind of the problem. Coming to the second thing, which is cruelty defined. So earlier also we have a cruelty defined in IPC and 498 section of IPC has this provision, but right now this provision has been formulated in a different manner, and in which cruelty is defined against a person, and especially it has defined in terms of the women, that if any woman faces any kind of cruelty by its husband, by her any in-laws, and she is sexually and physically and mentally tortured by any person, so that term is called as a cruelty. So it has a given new terms of reference for the cruelty, and mental illness replaced by the unsound mindedness of India. So right now we have seen that there is lots of awareness about the mental illness, mental health. And in the earlier version, the term mental illness has been used. So many experts have said that mental illness is showing the narrowness of a particular thing. So it is also limiting a thing. So that was replaced by unsounded minds And what is unsounded mind? So it has created ambit of various other things also, not just the depression and other things. Here, if you have any intellectual disability, that you are not able to do self care, you are not able to comprehend anything, so that is also termed as a unsoundedness of mind. And then coming to the third point, which is enhancement of minimum punishment for mob lynching. So earlier we have the punishment for 7 years if any person is died through the mob lynching, and right now this terms of definition has been changed, and maybe it can give you life sentence if the person is murdered. So from 7 years it has given to the life sentence, because so many people have opposed this thing, that so many people died in the mob lynching, and to that punishment only 7 years given to the convict. So this is not done justice to the people who have died in the mob lynching. So for that the greater punishment has been according to those number of the people. And what is the mob lynching? So more than 5 people are any threatening person physically or harming or mentally any doing harm to any person, so that is called as a mob lynching. And adultery and section 377 ignored recommendation. So in the earlier version it has been asked that there should be a use of term of a gender neutral provision and criminalizing adultery, but this provision has been ignored because so many experts have said that, you know, if a man is raped by a man, so what is the legal remedy for that thing? So they had suggested that it should be used in a gender neutral term, but this recommendation has been ignored. And coming to the next point, which is petty organized crime redefined. So earlier, if you are any endangering your identity, endangering your physical things, so that is called as a petty crime. But right now this definition has been broadened, and there is a particular uses of few words, just like trick theft, theft from vehicle, dwelling houses, business premises, cargo theft, pickpocketing theft. So they have used particular terms, that not only the showing of inferiorness or showing or any looting of any kind of particular thing is called as a petty crimes. Now they have given the particular definition, and they have given few words to define the petty crimes. So moving to the next suggestion. So Bharatiya Nagarik Suraksha Second Sanhita 2023. So what recommendation it has given and what changes it has brought? Community service defined. So here community service is defined in a different way. Some we have seen that the court is giving to punishment to a person, that if you have committed this kind of crime and if you have committed particular kind of offense, into that you have to serve the people and you will not receive remuneration. So these kind of community service is redefined into this thing. And handcuffing also. So earlier we have seen that there is a handcuffing for the protection of police and for the protection of civilian for particular kind of the person. But right now we have seen that, you know, so many persons who have not committed any physical crime, rape or murder kind of thing, so they are also handcuffed if they have committed any economic forgery. But right now the recommendation says that if any person who has committed economic forgery or economic offenses, so there is no provision of handcuffing those person. If any person has committed heinous or serious crime, just like rape and murder, so that person will be handcuffed. And then proceeding via audio visual means. So here is a provision for the proceeding via audio visual means, and here they have given a particular kind of thing, that what you can record through audio visual. And this is the hearing on discharge, examination of witnesses and recording of evidence in a audio visual means. So what we have seen, that they have particularly defined that onto this matter there will be the proceeding for audio visual thing. And then police custody beyond the initial 15 days of arrest. So earlier provision says that there should be the 15 days police arrest, but right now this has been extended to 60 and 90 days, which has also created another set of controversy, because that will give extra powers to the police administration. Preventive detention powers. So it allowed the police to detain person who do not confirm any directions issued by the police or prevent commission of cognizable offense. So what is this cognizable offense? In that offense you have to take warrant from the police, and you don't have to take any warrant from the court, and it is a very serious offense, just like rape and murder. So preventive detention is applied to that thing. Moving to the next set of bills, which is 𝐸 𝐶 second bill 2023. So there is only one changes which has been made to this thing, which is admissibility of the electronic evidence. So earlier you have to show the certificate, but later it got changed that you don't have to show the certificate for the electronic records or electronic evidences. So right now also you don't have to file a certificate, and you don't have to show a certificate for the electronic evidences just like audio or visual. Here it is, you can directly show the evidence, and you don't have to indulge into the matter of certification and everything. And they had also provided that section 65 of the Indian Evidence Act now, which is under section 3 of the new 𝐸 𝐶 bill 2023. So these are the changes which has been brought into this new bill, and it has been already passed in Lok Sabha, and it is going to be tabled in today's Rajya Sabha. Moving to the next slide is what are the issues we have. So the first issues the political opposition has raised, that in the absence of 97 MPs, this particular bill has been passed, which is injustice, because the opposition's leaders' voices has been not recorded, their mandate has been not recorded. And the second thing is that attack on civil liberty. So how you can do attack on civil liberty? Because here the police detention and police custody has been increased to 15 to 60 days and even to the 90 days, which has given extra power to the police, and it will create another kind of burden on the police also, and also on the judiciary, because so many cases will remain unresolved. So this is also the attack on civil liberty, because here if any person is proved as innocent, then they don't have to spend 60 or 90 days in the jail. In 15 days there can be given solution to that problem. And the second thing is that Muslims and Dalits will be heard. So the Asauddin Owaisi had said that it is the Adivasi, Dalits and Muslim who are registered as criminals in the police station and also in the judiciary. And many times we have seen that more number of people from these communities are taken to the jail, but most of the times they are innocent. So if the police custody will be, the duration of the police custody will be increased, it will harm more the liberty of the Muslims, Dalits and Adivasi people. It means overall it will directly impact the marginalized section of the society. And third is definition of terror is too broad. So here we have seen that terrorist act, which has been defined as a UAPA act, and whatever the terms and provisions which has been UAPA, it is also included in the terrorist act. The difference between is that in that serious crime is accorded, and here only petty crimes is accorded. But what we have seen that for the petty crimes and for petty organized crime and small crimes, we don't have to take consideration of the UAPA. So here the terrorism definition is too broad, and it can bring any kind of terrorist activities or any kind of activities which are not even terrorist in nature. So that has these kind of things has given a question and given concerns to the minds of opposition leader, and so many civilians are also opposing this bill because it is harming their liberty. Moving to the question side, which is the practice question for prelims. What key change does section 113 of the revised bill make to the definition of terrorist act, and from which legislation is this modified definition adopted? So we are here talking about Bharatiya Nyaya Sanhita bill 2023, and your options are broadening the definition based on the bill's principle, narrowing down the definition following international recommendations, entirely adopting the UAPA's definition, introducing new criteria inspired by the global counter-terrorism models. So we already had discussed the UAPA definition, counter-terrorism models, so you can easily bring the answer in the comment section. Moving to the mains part, which is examining the key provisions and objective of the criminalization bill recently passed in Lok Sabha aimed at strengthening the criminal justice system. So first you have to give background about the India's criminal justice system, and you have to also mention that we have few existing laws related to criminality, but that are very outdated in nature, and that is not suiting the demand of today's population and today's justice system. So in order to strengthen the justice system of India, these three bills have been tabled in the Lok Sabha, which has been already passed in the Lok Sabha, and now it is going to be tabled in the Rajya Sabha. So this is the background you have to give, and for today's stance we are taking this kind of the stand whenever your exam will come, maybe this bills will become the act, so you have to write accordingly. You don't have to mention the bill there, you have to mention the act there. So this will be the background. And then what are the provisions? So the provisions is that we have a redefine of various things. The cruelty is redefined, terrorist activities is redefined, we have a different rules and regulation for the article 377. So these are the provisions we have included in these all three bills. And you have to also be very careful, because here we have discussed three bills. So you have to be careful that which kind of bills they are asking and which kind of acts they are asking, and you have to answer accordingly. So that's it for today's lecture. If you have any query to this lecture, kindly ask in the comment section. Thank you. The PDF of this session is available on Telegram, so you can take PDF from there. Thank you.